So I have a question about footnote 99, I guess, which is to say a question about the public rights doctrine. Because it seems to me in addressing you spend a lot of time addressing the idea that there's sort of a non-coerciveness exception to the non-delegation doctrine. And I think this is very persuasive that that's not the right way to think about such an exception if there is one. But it does seem like the more plausible exception, or the more plausible would be that there's something like a public rights exception. And as you note, the public rights exception for purposes of Article 3 adjudication recognizes broad executive acts. And I don't think it's your burden exactly in the paper, but I'm just genuinely curious whether you think there's any reason that wouldn't carry over here too. Because I take it in the non-Article 3 adjudication setting, we say the implementation of these taxation powers is a form of executive power for reasons. And if it's a form of executive power there, wouldn't it be a form of executive power here? But I meant to say this actually before asking my question. I'm just such a Chicago person. We don't normally say nice things. But I think this is a really important and terrific paper, and it's probably done more to dislodge my tentative belief in the non-delegation doctrine than anything else I've read. So it's something I'm thinking about a lot, but I'd just like to hear more about how it works.
Jason?
Great, thank you. So Nick, I wanted to raise another example, and I don't know if it helps you or if it's more sort of on the Jen side of the ledger, or maybe neither. But your paper made me think about another example that I'm familiar with, and I'm wondering whether what you describe is conceptually different from early federal reimbursement programs, and in particular with respect to federal deployment of militia units. So states would send to the War Department bills for the expenses their militia had incurred in federal service, including in Fry's Rebellion, one of the things that you're interested in here. And Congress had made available by statute a total budget and said the militia were to be armed and equipped at the expense of the United States. But the states in the first instance had to do the arming and the outfitting of their militiamen. And so then afterwards they would send bills to the Secretary of War, who has to decide what to cover and to what extent. Was the state supplied knapsack or musket more expensive than they warranted? Did you really need the new musket that you purchased? All under some expectation of acting equitably. And to go to Jen's point, with a total budgetary cap on the total amount that could be spent. And of course, with rivalries sort of across the states as to their relative burdens, and rivalries within states as to who's going to get paid and who isn't. So I don't know whether that's an example that helps you, or if it's one that Jen would say. You see how limited all this stuff really is. It's just a kind of factual determination within a sort of set congressional cap, or maybe you think it's neither here nor there.
Mike Ramsey, please.
Yeah, so thanks for this paper. I really like this paper. I thought it was super interesting, and I like learning about new things. And I think I know a lot about the late 18th century, and then I found out there's this whole area that I know absolutely nothing about. And so it's just great to hear all this. And so thanks so much for that. I wanted to push on a question that Jen raised, and I think has been alluded to by a couple other points, including your response. But and to what extent is this not what was going on here? To what extent is this not just determining a factual question, although it is a factual question? And in that sense, it's not really novel as compared to other things that were going on at the time. And so what struck me, for example, is the determination of tariffs. So a tariff, like a real estate tax, is a percent of valuation. So the tariff rate was set, but then the valuation had to be determined by customs, and that was done in the executive branch. And I assume that everyone assumed it would be done in the executive branch, and there wasn't any doubt about that. And so my question is, to what extent is what was going on with the real estate valuation different from that? I understand that it's different in degree in some senses because land is harder to value, and there was more valuation going on, and so forth. But could you point to me what is it that makes the real estate valuation different in kind rather than in degree, in a way that's relevant to non-delegation doctrine, from what would be done in the valuation process, for example, in customs?
Regarding the factual question, I mean, so I mean, I don't want to say very much about customs valuations of goods that are being imported into the country, because I haven't gone into the primary sources on those. I went in the direction of land taxation rather than that, in part because Jennifer Mascott had already done a great deal of research on the customs statutes. And I suppose, I mean, when you're talking about ad valorem customs duties, as opposed to the specific ones based on quantities, I mean, perhaps there is no difference in kind. I think the difference in degree is very, very large. I mean, there's much higher levels of uncertainty given the liquidity and heterogeneity issues, and there's also this zero-sum dynamic that Boston's gain is Hampshire County's loss, and vice versa. Whereas the customs revenue just rises and falls with the valuation, with the total value of the goods being imported. I mean, on the broader question of whether this is factual, I mean that's a very important one, because even Justice Thomas recognizes a factual exception to his proposed ban on rulemaking. And what I would say is there is in fact great empirical uncertainty, or more than that, there's great methodological and definitional indeterminacy, which I think is even more radical. And I suppose perhaps that's a difference in kind, at least with commodities that are being imported and subject to duties, because there might be public markets as to those things, and you could just look at the current price in a public market or something like that. You just would not have that data source with land. So there's in the absence of a public market, there's definitional and methodological indeterminacy. There's the uncertainty and the variation in opinion is recognized by contemporaries. They know how uncertain and wide open this can be. And then furthermore, I mean, and this is more on the factual question than on the valuation question, they're not seeking to answer questions of historical facts. They're not seeking to answer questions about things that actually happened in the past. Valuation, assuming we adopt a definition of something like fair market value, which they didn't specify. Assuming we adopt fair market value, what are you doing? You're constructing normal market conditions in your head, and then you're predicting a hypothetical future social interaction in which someone under normal market conditions buys this land. How much would they pay for it? So it seems to me that's obviously a kind of construction, and one that you're forced to make in the absence of a public market for a homogeneous good. So I mean, I think that's my those are my thoughts on that question. And then with respect to the public rights question, I mean, so I guess so yes, I mean, according to the emergent public rights doctrine as it emerges over the 19th century, I haven't looked as much into the 18th century originalist evidence for a distinct public rights category that includes both benefits and spending and taxes. But if those things are coupled, at least in the emergent distinction in the 19th century, it is an Article 3 distinction. It's an adjudicatory distinction. And I'm just not sure why that should be transferable to Article 1 and legislative power, especially given how large taxation looms in the imaginary legislative power that exists at the time of the Constitution's ratification. But it's true. There is this coupling of tax with a lot of other non-coercive things for purposes of adjudication that emerges over the course of the 19th century. I'm not sure about. I don't see the basis in discussions of legislative power in the late 18th century for reading it into those arrangements yet. With apologies for being selective, I suppose I'll have to think more about Jason's example, and I'll try to catch up with you about that.
Hey, yeah, it's certainly this paper makes you think of the public rights language from Murray's lessee in a totally different way. Okay, our next trio is Eric Segal, Christopher Green, and Ilan Mormon.
Thanks. First of all, thanks to Mike and Stacy again for making all of this happen. It's just so wonderful to be with everybody, even if virtually. Nick, congratulations on an original paper for an originalism conference. I really enjoyed it and thought it was great. I think I have an easy question about the weeds, might even be a yes/no question, and then a very hard question about something else. I'm wondering if when these massive federal regulators went into the states to try to figure out this valuation, and I apologize if you covered this in your paper, did they rely on or even stronger demand the assistance of state officials in looking around, seeing what's out there, figuring out comparative value? And I asked that question because, of course, one of my least favorite cases ever is Prince. I think it's completely wrong in every way. And I'm wondering if there are examples in this regulatory framework of requirements on state officials to help. And that might be a yes/no question. I don't know. Although it also occurs to me that Justice Scalia's statements in Prince about the degree of reasonableness that the sheriff had to use was actually a policy question, might be relevant to the question that was raised earlier about policy versus fact, because how hard they would try to do this right might be a type of policy question, that would be relevant to that. My harder question is, at the end of your paper, I assume this is coming, I am very curious about the weight you want. Let's assume everything you're saying is 100% correct, and I'm very happy to assume that. How much weight do you give it in the contemporary context? And this is what I mean by that. Let's say that you're 100% right, but then the New Deal happens and the world explodes, and now the executive branch is far more powerful than anyone in 1789 ever would have imagined in their worst nightmares. And now maybe we have to cut back that. I don't believe that, of course, but for those who do believe that, I'm wondering how much weight to give the original evidence if in fact the power has been abused. Again, I don't believe that, to such a degree that we're going to say, well, we've gone too far. Despite what we did then, the pendulum has to go back the other way. So I am curious about the weight issue, which I assume is coming, but I didn't see in the paper.
Okay, Chris?
Yeah, so a fascinating paper, all kinds of fascinating details here. So I was thinking about a couple of different provisions reading it. One is the Fifth Amendment just compensation clause. So anytime property gets damaged, a jury is going to have to figure out, well, how much is it worth? It wasn't for sale, hasn't been sold anytime recently. There's only one Blackacre. All the same stuff. This is just the same stuff that any jury considering a case with damage to a piece of property is going to have to consider. So that seems like it's, whatever the Brig Aurora type fact finding exception is going to be, it really seems it would be just very surprising if, even though you've got it's not an actual historical fact, there's all kinds of issues about, what is property and what is worth and what is justice after all those sorts of things. But they're in the kind of thing that you decide anytime you have just compensation. So I guess this whole thing seems very, very different from, telling the EPA, solve global warming, okay, somehow. So that's one thing. Another is the 194 bit, the Article 1, Section 9, Clause 4 fact that all of these decisions are just intrastate. So if a state didn't like, if Pennsylvania or New Jersey or Delaware didn't like what these federal boards were doing, they can, it's in their complete discretion to just change the result. As long as that, because the statute specified how much money each state had to contribute down to the penny. And as long as that state did that, well, once the feds leave town, once we win the quasi-war, or whatever we did, I mean, the states can just reallocate that money however they like. So something that, just doesn't end up in a final decision at the federal level, I'd be tempted to think if anything is a detail, something that is that is inherently confined within the iron gates of a state's borders would probably be a historical detail. But a number of points you said, oh, it doesn't have to be different. It doesn't have to be the same in different states. It actually has to be a different rate of taxation in different states, and the different different rural versus urban divides in different states. Well, the states themselves can fix that if they want to. So anyway, those are two reactions. Thanks.
All right, Elon.
Thanks, Nick. I'm eating my words. I know I told you I probably wasn't going to comment on your paper since I'm already doing so in the same volume of the law review in which you're publishing this paper. But I guess I couldn't resist. So I want to just, home in again on something Jen said, and maybe it's beating too much of a dead horse here, but it really does seem to me that Congress made the regulation of private right in the sense that it decided to value the houses at true value. And knowing that would be subjective and cause discretion, right? Because what were the alternatives presented to Congress? Yes, of course, Congress could have said, well, we'll tax based on the number of windows, right? And then you were going to get the historic problem in Britain where they just boarded up their windows with brick and said, see, I don't have a window, and then the taxes is, So the policy, the key question is we are taxing your private property at its true value, as close to true value as possible. And how you figure that out varies from state to state, right? And you say this in your paper. So in South Carolina, they could consider the quality of the tidal swamps. In Rhode Island, historic land sales. In New York, rent, right? So I read Congress's statute as commanding the various states to use these various methods that are available to get as close to true value as possible, recognizing, that there's some subjectivity and variation in the available data. So when a state says tidal swamps, look at when the assessors at the state level, at the board level, right, say look at tidal swamp, look at rental data, right? Is that a regulation of private right, or is it just implementing Congress's regulation of private right? Right. And so similarly, the Board of Revisions, right, the 40% increase in Baltimore. I mean, the concern was, and I think you talk about Gallatin, or I don't know if you quote it, but was how can we trust the assessors in Philadelphia to assess the houses properly? They're going to undervalue because they want to pay less taxes, and there's a risk that in the countryside the assessors will do the same thing. So we want to equalize. And Jen talked a little bit about this, but Wolcott, Secretary of Treasury Wolcott, interpreted fair and equitable to require equalization, right? And so again, all of this seems to be implementing Congress's decision to tax at true value, which was the regulation of private rights. So I would want some elaboration on that. And I guess I do have a question, and I know, sorry, how important is it that it's a rulemaking versus something else? Because it doesn't strike me that what Baltimore did was a rulemaking as opposed to an order, 40% increase in order to equalize the valuation. And that's, so does it matter? It always struck me as weird, by the way. I don't think it should matter for non-delegation purposes, whether private rights are affected through an adjudication or a rulemaking. So does that matter in your view? Should it matter?
In answer to Elon's question about rulemaking versus adjudication and should that matter, I mean, I'm not sure. My focus on the rulemaking status of the revisions which I'm really just taking from the bimetallic investment company case. Although, I mean, I do think the bimetallic investment company case is a reasonable definition of what is a rule. I mean, it's it's some generic directive that determines a large number of individual outcomes for individual parties. So I mean, I think it's rational to call it a rule. As to whether it should matter that it is a rule, my emphasis on that is really just reactive to Justices Gorsuch and Thomas, and the fact that they put a lot of emphasis on the distinctness of rulemaking in their view in the Gundy and Amtrak opinions. Obviously, you have not. I mean, you have a more capacious view of the doctrine, as do several other scholars. I mean, that's an important debate, but I'm just kind of reacting to one part of that debate most directly. You also say, well, couldn't they just be looking to true value? And this is essentially a fraud prevention exercise. And it's true, there was an incentive to fraud in having these decentralized assessors across the state. And there was a fear that they would, fraudulently lower the valuations. And one of the purposes of the federal tax commissioners was to head that off. But I just don't think it was the only purpose. I think, they were there not only to ensure that the lower level officials were not playing games and committing fraud, they were also there just to ensure some kind of uniformity of principles. And when people talk about this, I mean, yes, they do talk about the bad incentives, but they also just talk about, differences in principles, differences in ideas, differences in opinion. And I would say, indeed, that the widespread existence of good faith differences of opinion is what makes the fraud possible. There's much less anxiety about fraud as to counting the number of barrels on a ship or something like that. It's the subjectivity of the enterprise when done in good faith that opens the way to concerns about fraud. And then as to your other question of isn't Congress importantly making a choice here? Given that they decide to base it on value, and what were their other options? Well, they could have said, in every house, so many cents for every staircase, so many cents for every chimney, but that would be extremely crude. Yes, it would have been crude, and they chose to do something less crude that required more administrative discretion. But I think once you get into but I mean, one of the costs of legislative assertion is crudeness. So, I mean, if we're going to justify delegations on the ground of avoiding crudeness, then I think that opens up a significant space for delegation. And furthermore, I would emphasize they had yet other options besides taxing a house at so much per chimney or per staircase. It was also possible for Congress to do what the state legislatures had always done and determine, average per acre values or equivalently total aggregate tax values, not only for the states as they had to under the Constitution, but also for every county within every state. And Congress did that in the direct tax of 1813 to finance the War of 1812. They then started to think it was too crude or what have you, and they went back to administrative federal board mass revision in the 1815 tax. But there were other options here by which Congress could cut down on discretion more, and yet they opted not to do that, both in 1798 and in 1815. And then again, with apologies for being quick, in response to Chris Green's question, I want to be clear because this is a kind of a technical point about the statutes, and forgive me if this is a misunderstanding of your question, but the state legislatures did not have the power to override the federal officials' valuation of all the land in the state. They did have that power. They were given that power under the 1813 tax, but they did not have it under the 1798 tax. The only way for the state legislature to override or redress any federal distributional inequity that they felt had occurred within the state would have been to impose a state tax that somehow was calculated to cancel out the federal tax, which to my knowledge, none of them none of them did. But there was no provision in the federal legislation for a state legislative override, as there was later in 1813, but not in 1815. You ask a very important question about, isn't the valuation of land a familiar jury determination in litigation, such as on takings? I mean, yes, yes, it is. In lots of kinds of litigation, the jury would determine the value of some parcel of land that was at issue. So does that mean that we can comfortably place this mass administrative valuation determination into a factual category or a fact exception to the non-delegation doctrine? I think not, for two reasons. The first is that to say that it's a jury question, I think is at most to say that it fell on the fact side of the line for purposes of the binary distinction between law and fact that exists for the purposes of litigation. But what Justice Thomas and several others have posited regarding exceptions to the non-delegation doctrine is not a law-fact distinction. It is a law policy, it is a fact policy distinction. And indeed, as Mike Rappaport has elaborated in a recent paper, there's really a tripartite distinction going on between law and fact and policy. And now Mike and Justice Thomas both think that, the policy thing is off the table for administrators. I differ with them on that. But in litigation, everything has to be a law or a fact. I don't think that's the case in the theories that are being developed for the non-delegation doctrine. So that's one reason. The second reason is simply that the mass valuation decisions being made by the federal boards are they're larger and more complex by orders of magnitude. I mean, there's one federal board for all of Virginia, which includes approximately 1/6 or 1/5 of the total U.S. population at the time. They're to divide the state into geographic districts and determine the average per acre value of land in every district relative to one another. I don't think a court or a jury was ever called upon to do anything that was 1% that complex. And I think at some point a difference in degree becomes a difference in kind. And then finally, in response to Eric, there's a very interesting question. As the executive branch becomes more powerful, should the non-delegation doctrine itself adapt to maintain some kind of constitutional balance? That may well be the case. I think there we're getting beyond originalism, perhaps, or at least we're getting to the point of adaptive reactions to other changes in governance. And I don't know that originalism can answer that question. And it's a very important question. I honestly haven't thought about it yet for purposes of this paper, but it's a good one. And then on the Prince question, did they rely on state officials? There's no provision in the statute that commandeers state officials. And there's one provision that says they should identify the property, not value it, but identify it. And in so doing, it can be done by reference to state records. But as to whether they were relying on state records to kind of plug in values to the federal valuation, they could have. I haven't seen records of them doing that. The instructions by the New York board and the Pennsylvania board, both federal boards, both expressly say it is only optional to do that. So they did not view it as required. And certainly there were several states where the valuations departed widely from what had been the state government valuations. So we know they were not following state valuations in several of the states.
Okay, thanks so much. We have Larry Solom, Richard Epstein, and then Gary Lawson. Larry?
Thank you. Wonderful paper. I really enjoyed it. And just on a personal note, it's nice to hear something about Fry's Rebellion. My partner is a direct descendant from one of the participants in Fry's Rebellion who was convicted of treason, and she is only alive because he was pardoned by President Adams. So one comment and then a question. So the comment is this. This historical practice evidence that you've got, it's clearly pro tanto evidence that is relevant to original meaning. It's not decisive evidence. There are all kinds of reasons why even early historical practices can be inconsistent with the original public meaning of the constitutional text. But I take it that it's strong pro tanto evidence. And the question I have is evidence of what theory of the communicative content of the relevant constitutional provisions, right? So as far as I can tell, you don't present in this paper or the supplemental paper any theory of the actual communicative content, the proposition conveyed either by Article 1, Section 8, Clause 1, because this might be an issue about the propositional content of that clause, or of Article 1, Section 1, the general delegation of legislative powers in juxtaposition to Article 2 and the vesting of executive power, as well as Article 3 and the vesting of judicial power. So I think this is an area where I want to know, some people say it takes a theory to beat a theory. I think someone who said that is about to ask a question. So what is your theory of the propositional content of the relevant positions? Because only when I know that can I know whether or not, from an originalist perspective, I think that the pro tanto evidence you've presented is sufficient to make out your theory and defeat opposing theories.
Yes, I have a couple of questions and observations. One is, in order for this to be, I think, a really strong attack that there's a kind of unqualified delegation, one would have to ask the question of, suppose you decided you didn't want to do this by delegation. Is there any conceivable way that a legislative body could make these individual determinations with respect to the value of particular pieces of land? And I just find it, utterly improbable to do so. And historically, this reminded me actually of the Domesday books, about which Maitland talked at great length, where back in England, you did exactly the same thing. You had to find out what the value of all properties of land were, not for the purpose of a direct tax, but for something else. And what you did is you send the various knights and squires out, give them general instructions, and off they go. So to me, this is a proper delegation. Mainly because the alternative is complete paralysis of government. And so I am just not persuaded that somehow or other this case shows that there's no non-delegation doctrine. I think it shows the opposite, that there's a sensible non-delegation doctrine. Or to put it another way, suppose, Nick, what they had done was to change this and to say, look, we're going to let the local guys decide exactly how much tax they want to raise by this and what kinds of formulas they wanted to use, and figure out what the allocations were across states. That is, if you start to remove all of those constraints, I think you could make the case credibly, but this just strikes me as being a sensible mix between the two functions. So that's the first one. And the general observation is, I think the beginning is like a slightly hysterical tone. I think that Gundy should, as did most people, have been regarded as an improper delegation, because the facts are so widely divergent from those in this case. Why is it that you would want to allow the Attorney General to make a retroactive decision when he has no administrative advantage over the Congress? That's just punting a legislative decision downstream, which is impermissible. And so it seems to me that what one can do is to say that Gundy was wrong, notwithstanding the earlier cases, and that the way you'd want to do these things is to pay more attention to the details in the system of delegation and organization before one makes this kind of judgment. That said, the historical stuff about the relationship between direct taxes and indirect taxes, that's a real eye opener. So, the historiography strikes me as being impeccable. But I do think that the implications that one case is wrong that is, this is an unlimited delegation case is wrong. And that two, I don't think that anything you want to do with respect to the land tax tells you what you ought to do about a delegation of whether or not an entire statute should apply to a given class of people, which is what you had in Gundy. So I think they're really distinguishable. You could overturn Gundy tomorrow, as I argued in my paper, and the horrible administrative state post-1937 survives quite well.
All right, thank you. Next we have Gary Lawson.
Hi, thanks. As you know, I think this is a terrific paper. This follows actually on what Richard just said. There's another paper circulating right now by someone named Chad Squidieri, who I've never met, that argues that instead of thinking of the delegation doctrine in the abstract, one needs to locate it clause by clause by clause. And the more I've thought about this whole delegation issue, the more convinced I am that that's essentially right. To the extent that this is all grounded in agency principles, it depends very much on what the tasks are that you've committed to agents. And I know a lot of the early examples, not just the ones you have, but the creation of collection districts and the like, those all seem to focus on taxation. So I guess this follows Richard's question, is this really a data point about delegation with respect to tax collection practices, or is it a data point with respect to the capacity, let us say, to delegate to the Federal Reserve Board the power to regulate the value thereof of money? Does the one follow from the other?
So on the point about Gundy, I mean, yes, I mean my understanding of Richard, of your response to Gundy is that I think you have a narrower theory on which Gundy could come out the opposite way than is articulated by Justice Gorsuch in his dissent in that case, and certainly a narrower theory than is articulated by Justice Thomas in the Amtrak case. And I guess I view myself as responding to the theorizing on the part of Thomas and Gorsuch, although I mean, yes, you could come out differently in Gundy on a narrower theory. I believe a gateway theory, as you refer to it in your recent paper. Although I'm not, I mean, and I see the argument you're making that we could have, kind of a functional agency cost-based analysis of which delegations are legitimate as a constitutional matter. I mean, there's a strong logic to that. I mean, absolutely. I suppose it would also be subject to an objection along the lines that Justice Scalia would make about strong judicial enforcement of the non-delegation doctrine, because do judges have the institutional competence to calculate the relevant agency costs in order to draw the lines? But as an ideal toward which to aim, there's a lot that's attractive about it. I suppose as you suggest, one of the ways in which the agency cost analysis could be cashed out would be to distinguish between gateway issues and non-gateway issues. Is this person subject to regulation at all, versus how much regulation are they subject to? But I mean, even there, I have some questions. I mean, so yes, I mean, Congress absolutely makes the determination of which property is subject to the tax, and therefore which owners are subject to the tax. But then the boards have, this very broad discretion over, what the taxable value is going to be. But I mean, I see what you mean from a formalistic perspective. There's a big difference between those, but from kind of I guess an economic perspective, I mean, there's the difference between being taxed $0 and being taxed $1, and there's the difference between being taxed $1 and being taxed $10. From a formal perspective, the first one matters more. From an economic perspective, the second one matters more. So I mean, I'm not, I'm not saying that I reject this reading of the doctrine. I'm just saying those are my questions about it at this point. To your first point about would it have been feasible for Congress to do anything else? I think it would. And I mean, obviously, I concede that it would not have been feasible for Congress to determine all of the individual values of individual parcels across the country. But it would have been feasible for Congress to draw the intrastate tax districts, and it would have been feasible for Congress to determine in the legislation the average per acre value of each tax district. And in fact, Congress did that in 1813, and then they went back to administrative discretion in 1815. And I mean, that to me is the really, kind of important decision here that's being made by the administrators. And so I think it was feasible for Congress to do that. Also, I mean, even in 1798, when they didn't, have a federal valuation to work from, it would have been possible to pass the act, have the administrators go out and make the valuations, have the boards make the adjustments, but not enact any tax yet, and have the information flow back into Congress and then vote on whether to impose a tax. Now, they were somewhat rushed because of the quasi-war, but this was only necessary to pay for like 25% of the war or something like that, or even it was only 25% of the federal budget once it came in. The revenue didn't come in for 1 or 2 years. So I mean, they could have acted differently, I think. Now to Larry and Gary Lawson's overlapping questions about what does this say affirmatively about the meaning of the tax clause of Article 1, Section 8? What does it say affirmatively about the meaning of legislative power more broadly? Or I guess Gary is suggesting that may not be the relevant question. You have to look to the individual Article 1, Section 8 power. I don't think I have an affirmative theory. I have a data point. I think it's an important data point. Does it take a theory to beat another theory? Well, I guess that depends on the context in which you're working. When you've got many years of stare decisis about permissiveness, and you want to overthrow all of that, I don't know that we're under an injunction that you need a theory to beat a theory. The theory we currently seem to have is unless you do a Schechter-like thing, everything is okay. And then relatedly, we have Justice Scalia's theory in Mistretta that that this is generally beyond judicial competence, which I suppose is pretty good. Is a pretty good theory, but no, have I constructed from this an affirmative theory? I don't think I have, and that's that's an important thing that you could attempt to do with this that I don't think I've attempted to do yet.
John, Mikhail, you can ask your question if you promise to ask it really quickly.
I will. Thank you. Excellent paper, Nick. The question is, the question is just to invite you to comment directly on what I think is a tacit premise of your article, which is an embrace of what we could call an early federal Congress canon, or first federal Congress canon, according to which what the early Congresses did is presumptively constitutional. I'm sympathetic to your paper, but the counter argument would be that by 1798, we have quite a lot of examples of the Congresses doing unconstitutional things. So a quick list might be, if Marbury's correct, the First Judiciary Act, the Invalid Pensioners Act, if Hayburn's case is correct. In 1797, the House impeached a senator. Today, we think that's unconstitutional. The Alien and Sedition Acts themselves. So could you just squarely address what I assume will be a counter argument that gets into the mix here about this reliance on that premise?
Yes, and I do seek to address that in a portion of the paper that wasn't assigned just because of length. In part 5 of the paper, I try to go through the entire published discourse about the tax, which is quite extensive, and I don't see any contemporaneous constitutional objections. And I actually use the Alien and Sedition Acts as a counterpoint because there were copious contemporaneous constitutional objections to those statutes, and I think you can draw a kind of negative implication from the lack of such objections to the 1798 tax, which was discussed very extensively in other ways at the time. So I mean, that's my theory of why we needn't worry that this is early unconstitutional behavior. If I may, I apologize for not responding to Jason Mazzone's comment earlier. I believe the queue is empty, so if I may respond to that. Yes, I mean these. I think these. I think the example you bring up about strong discretion to determine reimbursement of the states for military operations is very important, and I think it was not an example I was aware of. I think it is in the same vein as examples about presidential laying of embargoes or presidential control of the military disabled list or that kind of thing that we see in other legislation. I gather that Justice Thomas or Philip Hamburger's objection to the use of that example would be that there's not the direct effect on private rights. In some sense, what I'm attempting to do in this paper, and again, in response to Larry Solom, this is less an affirmative theory than a matter of, just, kind of making what I hope are incremental improvements in our understanding. I'm trying to show some similarity between the treatment of private rights in the direct tax and the broad delegations that you observe with respect to things other than private rights in the context of military reimbursement or merchant sailor benefits or any number of other things. Thank you very much. I really appreciate all these incisive comments. I greatly appreciate it. Thank you.